all of them look at it, all of them.
Going authorities have cited, I am bound with the same. It is this court's opinion, therefore, that the question of law proposed and framed by counsel for the accused persons for interpretation does not involve a substantial question of law for interpretation of the Constitution. The allegation that there is a likelihood that the accused persons who complained against the trial judge for Judicial Service Commission will not get a fair trial is an imagination, because Article 28 of the Constitution lays down all the principles of the right of a fair hearing, which court is mandated to observe and cannot be compromised by the trial judge. I have put into consideration the cases referred to by counsel for A1 and A2, that is the case of Professor Isaac Newton of York. However, it is my finding that the authorities referred to relate to the bias, not directly relate to the constitutional reference. It is my view that this court is not satisfied with the question of law framed for constitutional interpretation. In the final result, it is this court's finding that counsel for the accused person have not made out a prima facie question of law to warrant reference to the constitutional court for interpretation. I accordingly decline to refer the proposed question of law to the constitutional court, and I direct that let the matter be fixed for scheduling and free-taking the so-called.
Judicial sham. Yeah. We are tired. Yeah. It's a judicial sham. It's a no. This is a sham. Let me speak. It's a judicial sham. No, I will hit you. It's a judicial sham. It's a judicial sham. We are tired. We are tired. We are tired. Where is justice? Where is justice? Let me talk to him. Where is the justice? Where is the justice? Why are you doing this? Where is your parent? Leave me, leave me. Every time you wasted our time for 1 whole year. 1 whole year to journal so much script. Is this a theater? Is this a theater? Is this a theater? Get your script and take it to the theater. This is not a theater. I'll speak.
Who wished to come in and who were complaining that they were barred from coming in. They had been there since 8 o'clock.
That one we shall discuss, so we can have a meeting with security.
Has been here.
Let us pass by the post.
You people need to know what is the daughter was. Mr. General, justice. Not the balance.
So this being a public trial, we are urging the court to order the orderlies at the front gate of this court building to let members of the...
It's okay, I will come back to that. Let me first go to the way forward of 3:15. I will come back to that.
Way forward, we were also going to come back to that. In view of your ruling, we will need to take instructions from our clients. We did not expect or know how the ruling would go, we naturally need to go and take instructions. We would also urge that the orderlies in court, even when removing a person who is agitated, they must not mishandle. They should handle people properly, and especially if it's a female, she should be handled with extra care, lest the handling amounts to indecency.